A federal high court in Abuja has ordered the reinstatement of two aggrieved directors of Green Energy International Limited, Dr. Bunu Alibe and Mr. Olojede, who were illegally removed by the company's management. Justice Bolaji Olajuwon, in a judgment, described their removal from the oil company as unlawful. Olajuwon said that the annual general meeting AGM of the company, held on November 12, 2020, during which Alibe and Olojede were removed, was convened in contravention of Section 285 of the Companies and Allied Matters Act, CAMA 2020. The judge, who ordered that all the backlog of the directors' entitlements, including salaries and allowances, be paid, also awarded 3 million naira in favor of the duo for damages. The news agency of Nigeria, NAN, reports that Alibe and Olojede had sued Green Energy and Professor Anthony Adegbulugbe as first and second defendants. Adegbulugbe was a former special advisor on energy in the Olusegun Obasanjo administration. The plaintiffs in the suit, which commenced via a petition, accused Adegbulugbe of series of corporate misdemeanors, including unilateral usurpation of executive responsibilities contrary to the provisions of CAMA 2020 and the company's Article of Association. They claimed that they were unlawfully removed by the chairman of the company they jointly nurtured. Responding, Adegbulugbe also filed a separate suit against the two directors before the court. Although the matter was formally before Justice Ijoma Ojukwu, the case was reassigned to Olajuwon following the transfer of Ojukwu to the Calabar division of the court recently. Delivering the judgment, Olajuwon said that the notice of general meeting to all directors and members of the company must be given 21 days from the day it was issued. She held that the petitioners were only given 20 days notice instead of 21 days as required by law for the meeting held on November 12, 2020. According to her, Section 241 of CAMA provides a lengthy time to be provided for a meeting of a company to be held. The judge held that the argument of the defense that Ojukwu had ordered that parties should attend the AGM as part of the efforts to resolve the crisis rocking the company and that the aggrieved directors failed to comply did not hold water. She held that the petitioners were not given fair hearing in the decisions taken by the company. The judge also dismissed the sister suit filed by Adegbulugbe against the two directors. Earlier, Olajuwon had also dismissed the defense motion challenging the jurisdiction of the court to entertain the suit. Olajuwon, however, dismissed the allegations leveled against Adegbulugbe that he took unilateral decisions in the running of the company and turned the firm into a family affair. According to Olajuwon, he who asserts must prove. She held that the two directors failed to discharge the burden of proof of the allegations as no sufficient materials were placed before her to believe so. On the aborted Project Horizon contract, Olajuwon held that it was executed by Adegbulugbe in the interest of all the shareholders and the firm, while the petitioners could not prove the allegations against him.